I think really for the first time in my conscious life, the legitimacy of the Supreme Court has been called into question. And I think that's extremely dangerous for our republic, that ultimately we have a very complex constitutional system, and its legitimacy is in some sense the foundation of our system. We have to agree that even if we disagree with it, and even if we think that their decisions ultimately could be changed in an appropriate way through reconsideration at some point can be changed, it's essential to preserve the legitimacy of the court. And I think some of the attacks on the court are quite unfair and undermine that legitimacy. People have not liked the decisions of the Supreme Court from the beginning of the republic. And they change over time, and anyone who has a 200-year perspective on the Supreme Court recognizes that overall the Supreme Court has been a bedrock of protecting both our democracy and our rights. My name's John O. McGinnis, and I'm the George C. Dix Professor in Constitutional Law at Northwestern University. The Supreme Court is the national arbiter of our fundamental law. It plays an essential part in our constitutional system because we have a complex constitutional system. The framers designed a system where there are many moving parts. We have a separation of powers, separated between the president, the Congress, and the Supreme Court on the one hand. We also have a federalism. We have, in some sense, a vertical separation of powers, where powers are separated between the federal government and the states. We finally have a Bill of Rights, rights that individuals have against the government. And the boundaries of the separation of powers, the boundaries of federalism, the boundaries of our rights are all potentially contested issues. And the Supreme Court is there, as Alexander Hamilton said, because it's the least dangerous branch to rule on what those boundaries are. To understand the Constitution, one has to understand what happened before the Constitution, the Articles of Confederation, and how they succeeded, or rather didn't completely succeed, in regulating the country, and also how state constitutions often had less separation of powers than our federal Constitution had. And those issues caused some problems. The federal government didn't have enough power, and so there were trade wars among the states. And there was a fear that the federal government didn't have enough power to protect the nation. So one needed to create a more powerful federal government. On the other hand, the framers had a real fear of centralized tyranny. Of course, that's what the revolution was all about, rebelling against what they considered tyranny. And so the question was how to create a balance between a more powerful federal government, but one that would be restrained and make sure that it would not become tyrannical. And that required this complicated system between the separation of powers. The idea was to have a powerful government, but to have separation of powers so that that power could only be exercised to its full extent when there was a clear national crisis, when there was a clear consensus on what problem that needed to be solved. And that's why we have bicameralism. You have to get a bill through two houses of Congress and decided by the president. And we also have limitations on what the federal government can do. And so those limitations were the way to prevent tyranny while still allowing the federal government to act decisively within the bounds that the framers set. The colonists thought that the courts were in some sense instruments of the crown. And so during the time immediately after the Revolution, courts were not that powerful, but then the framers recognized through, I think, some excesses of democratic enthusiasm that they needed the courts to protect people's rights. Moreover, it was necessary to have a Supreme Court because what occurred to create a government of the kind of complexity that did these dual objectives of both creating a powerful federal government and yet restrained it, they had a complex government. And to keep that government on the rails, as it were, to make sure that it stayed within its boundaries, they necessarily needed a more powerful and a more focused judiciary, and they became more sympathetic towards a judiciary than they had in the colonial period because of these new circumstances. So the Supreme Court is essentially a reaction to a problem that the founders faced: how to create a powerful federal government, but one that kept within complex bounds, including the bounds of rights. And when you have those complex boundaries, you need some arbiter. And the question was then, who is going to be the arbiter? And it could not be the president, it could not be Congress, because they thought, understandably, that those would be powerful branches that would act in a self-interested way and might create more powers and therefore erode the very boundaries that were going to prevent the government from becoming tyrannical. So the judiciary became a main point of debate during the contest over ratification. The Constitution was put forward by the framers in Philadelphia, but then it had to be ratified among the states. And many of its provisions were controversial, but none, I think, more controversial than the judiciary, because, as many people suspected, the judiciary, partly from the experience of a judiciary in the colonial period being connected, doing the bidding of the crown. Another suspicion of the judiciary from what were called the anti-federalists at the time was the judiciary being appointed, the federal judiciary being appointed by the federal government, appointed by the president and then confirmed by the Senate, would have a natural inclination to consolidate the powers of the federal government. And the essential debate about the ratification of the Constitution was the federal government too powerful? And the anti-federalists thought that the judiciary, far from protecting and shielding the states by enforcing the boundaries of the Constitution, would, by its natural inclination of being people appointed by the federal government, consolidate powers and expand the powers of the federal government. They also feared that they would do that because they would have a loose interpretation of the Constitution, that they would understand it as an equitable doctrine and not be carefully confined by its words. So that was the challenge that the Federalists in the famous Federalist Papers faced in trying to rebut these arguments of the anti-federalists. So the basic arguments that the Federalists made were, first, that the Supreme Court was not going to be a powerful institution. They said, well, unlike Congress and the president, they didn't have the judiciary didn't have the power of either the purse or the sword, and therefore it was the least dangerous place to put adjudication of the Constitution. And in response to the Federalists' worry that, nevertheless, being part of the federal government, they were going to happily consolidate power in the federal government, they said no, that what was distinguished the judiciary was their attention to the written law and the precedents and rules of interpretation. They were going to be learned people who were going to have a kind of independence and be focused on the law, not power. And that was going to be the protection. So in some sense, it was ultimately a protection that was set in the sociology of the lawyers at the time, that Federalists said that those people would follow the legal rules at the time and interpret the Constitution as written and according to those rules and not be distorted by some interest in creating more power in the federal government. And that would become itself a powerful protection against tyranny. And that was their response to the important challenge by the anti-federalists, to say that the court would be a court of law and not affected by the underlying interests, their underlying interest as being appointed by the federal government. That was the essential debate, and the framers from the very beginning put their faith in a judiciary that would be regulated by law, not by interest. The most important thing to understand about the Supreme Court is that it is not a political actor like Congress and the president. It doesn't deal in its own preferences. It deals in reasons. It's perfectly legitimate to decide what you think of Congress and the president and decide just according to your preferences. Are they doing a good job according to what I think the best policy is? But that's not the question for the court. And that's not the question for you in evaluating the court. Is the court doing a good job in deciding the cases according to law and giving good reasons for it? That's a harder question. It's particularly a harder question if you're not a lawyer. What you need to do then is to look at the reasons the court is giving, which are not generally policy reasons. You'll have to read the statute, read the Constitution, understand what the Supreme Court is saying as a matter of reason rather than your own policy preference. Only then, I think, can you come to a considered judgment of how the court is doing. The mechanics of the federal judiciary are laid out itself in the Constitution. How people become justices, how they become judge are very clearly delineated. The Supreme Court is contemplated in the Constitution. There shall be one Supreme Court. That's part of Article 3 of the Constitution that sets up the judiciary. And their nominations are also set out. They're nominated by the president with the advice and consent of the Senate, which means that the Senate, as it wishes, according to its rules, will decide how to confirm justices of the Supreme Court. And the reason for that, again, is to protect our liberties by making it sure that the president can't unilaterally decide who's going to be on this most powerful court, but is going to have to get a majority of the Senate. Well, the best way to set out what the founders thought we were looking for is to look at how George Washington appointed justices of the court. He thought that was one of his most important jobs, and he said, I'm going to appoint continental characters, people, lawyers of really great repute and reputation. And also he was very concerned to appoint justices who were committed to the federal system, which not all lawyers were at the time. And so I think an idea of fidelity to our constitutional system was above all what George Washington wanted. So things became, though, a little more complex pretty early on in American history, because exactly what the Constitution meant and how it was interpreted in certain cases became contested. From the Bank of the United States, whether the federal government had a power to incorporate a Bank of the United States, was contested between our two great political parties, the Federalists at that time and what were called the Democratic Republicans. Democratic Republicans under Jefferson, the Federalists grew from George Washington and were under John Adams, and that was itself contested, and therefore people started to look to how the jurisprudence of various lawyers, to what they likely would think on the bench, not maybe in a particular case, but what their attitude was to the Constitution. And so at the beginning, Jeffersonians wanted what was called a strict construction of the Constitution, a strict construction of the federal powers of the Constitution. And the Federalists wanted to give more breadth to those powers, to give a broader interpretation of the necessary and proper clause. To be clear, though, all of these justices accepted the Constitution as a written document, and I think they were all, in some sense, what we in modern terms would call originalists, that they had slightly different views of what were the right interpretive rules to go about fixing the original meaning of the Constitution. So from very early on, the Supreme Court and the justices who were appointed became a question of party politics, precisely because these justices wielded a good deal of power. Nevertheless, there was, I think, agreement that these would be some of the best lawyers appointed across the United States. They would be continental characters still, in Washington's estimation, and that they still demonstrate a fidelity to the Constitution, even if there were slightly different views of what that fidelity consisted of. Moving to the modern times, I think we have even more contentious views for two reasons. One, the Supreme Court has become even more powerful because there are more federal laws, because some of the interpretations of the Supreme Court have given it more power in the sense that the Constitution regulates more areas of life than ever before. And so just the greater power of it creates greater contention among the different parties. And I also think that there is now less agreement on jurisprudence than there was even when there was contention even early on in our history, and as there has been throughout our history, because I do not think it is true that all justices agree that the original meaning of the Constitution is the lodestar of constitutional interpretation. Some think the Supreme Court has interpreted it enough that the precedents are more important than the original meaning of the Constitution. Others, like Justice Breyer, suggest that, well, we need to take a much greater account of what the consequences of deciding one case is one way or the other. And the Constitution really isn't that clear in many cases, and so there's a great scope for that. I think it's absolutely correct that the social media allows people to express themselves even if they haven't taken the time to learn how the Supreme Court works, and to recognize that many people, of course, don't follow the Supreme Court, they're not lawyers themselves, and can be easily, perhaps even more easily, misled about what the Supreme Court is doing than what other actors in our politics are doing. Because to understand what the Supreme Court is doing, you have to understand what's doing is law, not policy. And so given the rise of social media, it's very easy to collapse that distinction and therefore confuse people. In other words, to suggest that this is a bad decision because you should disagree with it as a matter of policy, even if it's the right decision on law. And it's essential to have a distinction between law and policy if we're going to have the rule of law. Our policy preferences today should not disturb what the law is of yesterday. Laws, in some sense, are always decided in the past, and they represent the policies of the past, sometimes very recent past, sometimes of a past long ago when it comes to some statutes and some constitutional provisions. And if we dislike the policies underlying them, the way of addressing that is to change them and to not do that through the proper process, either through legislation for statutes or constitutional amendments through the Constitution, gives power to judges to make policy rather than to us. For when judges say, well, this is what the law is, even if you don't like it, you actually are empowering the people. Would you empower the people then to change the law if they don't like what the law is? You empower them to change the Constitution through the constitutional amendment process. And this, I think, I just want to come back to this, because I think this is one of the most important points about how a judiciary that doesn't follow the original meaning of the Constitution disempowers the people. The people themselves are a continuing constitutional convention in this sense, that the Constitution can be amended when the legislature decides to have a two-thirds vote to put a constitutional amendment before the state legislatures. It also can be amended if the state legislatures call a constitutional convention. And that's the way that we, the people, exercise our popular sovereignty. So in protecting the Constitution as written, we're protecting our popular sovereignty today, our sovereignty as people to change the Constitution as we want, rather than to have some judges change the Constitution. And so that ultimately is another reason why attacks on legitimacy of the Supreme Court are so dangerous, because by setting out that framework of the Constitution as written, it's protecting not just the Constitution of the past, of the handiwork of the framers, it's protecting the way we, the people, are going to exercise our sovereignty to change the Constitution today. The Supreme Court and constitutional review of a written document is one of the great innovations of American constitutionalism, something that has been copied around the world. It is a precious heritage for us because it allows a complex constitution that protects our liberties both by dividing powers between the branches of the federal government, between the federal government and the state government, between our rights and any government to function successfully, because the boundaries of those divisions are necessarily unclear. The Supreme Court is not an infallible arbiter. It's not an arbiter that cannot be questioned. It's not an arbiter whose decisions cannot be changed, but it is an arbiter whose legitimacy is precious because of what it does to protect our rights as Americans.